1963. You had to be blind not to see it was a perfect love. It was a perfect love. Yeah, yeah.
May I just ask everybody to take their seats, please, so that we can recommence. Thanks very much. Hope everybody is well refreshed and ready to hear some more about how to protect your brand in the new gTLDs. That is the subject of this session now before our lunch break. And we talked some just now, we heard from Kurt Pritz about some of the protective mechanisms that will be in place as we move toward the launch of the new gTLDs. But we want to talk more about exactly what those mechanisms are, how they're going to work, and what brand owners can expect. And to do that, we have an eminent expert with us today. He is Dr. David Taylor he's partner at the international law firm HoganLovells, and he specializes in internet-related intellectual property and in particular the protection of brands online. He heads up a specialist domain name practice covering the centralized registration, recovery, and protection of domain names and clients' rights. Keyword issues, data protection, privacy, they are all among his areas of expertise. He's advised a wide array of clients on TLD launches over the last decade, and he currently serves as the IP representative for Europe on the ICANN GNSO Council. So we're very pleased to have David Taylor with us today. He will also be looking to hear questions from you, from the audience. He's got a very impressive panel of experts that will join him midway through to take your questions. So please do bear those in mind as you hear his keynote now. A warm round of applause, please, for David Taylor.
Thank you very much, Melinda. I think the best thing about talking at a session like this and having a panel following you is that they get to answer all the questions, so I get off scot-free, but I don't know whether that will be the case. What I'm going to talk about then today is, first of all, really setting the scene before launching into what protections there are for new gTLDs around the corner, what we're looking at today. So a little bit of the domain name industry, a little bit of brand protection in current TLDs, and then move on to the second section of new gTLDs themselves. And the background, the concerns, trademark protection, and then obviously considering a .brand as an option. First of all, I've got a few preliminary questions just to get an idea of the audience. Who in the audience has filed a UDRP as a brand owner or as counsel to a brand? 7, 8, 9. That's interesting. So we're not that heavy on the lawyer front on UDRPs for the existing brand protections. This was just in case there was a few people here. Who has had a UDRP filed against them? Who is willing to admit they had a UDRP filed? Next question, was it successful? Okay, who has attended an ICANN meeting? Okay. So there's our outreach. We've got a lot more attendees from ICANN meetings than IP. Who's read the applicant guidebook? Why are we here? Maybe I'll just give a presentation on the UDRP because there seems less people have heard about it. Okay, well, all you people who've read the applicant guidebook, which is significantly more, I think we're probably looking at 30, if not more hands. What's the first word on page 258, then? Nobody know? You haven't really read it. It's actually litigation. And I'll leave it there. So developments in the last decade, well, and Kurt mentioned these earlier, we've already seen quite a few new gTLDs. We've got the original Magnificent 7, as I call them. We've got the 2000 group of 7, where we saw the .aero, Co-op, Museum, Biz, Info, Name and Pro. We then saw in 2004 another 7 coming along. So we've got this 7's the key number. .asia, .cat, Jobs, Mobi, Post, Tel, Travel. Not all going into the route at the same time, some being more delayed than others, but a group of 7. We've then had the standalone, I should say, XXX this year. So there's only one this year, and it's .XXX. We're lucky to have Jonathan here, who is involved with the sunrise period there, so that'll be interesting for our discussions. And so we're looking 2012 and onwards. How many? We don't know. 7, 70, 700, 1,000, 1,500, as we heard before. The fact is nobody knows, and a lot of people are looking forward to find out how many there'll be. So we've got 2 kinds of TLDs. So all those people who attend ICANN, I'm really sorry for this, but I was told to make it fairly low and build it up quite quickly. We've got the generics, not the globals, the 22 gTLDs. We've got the 273 ccTLDs already out there. Back in 1992, we had fewer than 15,000 .coms, and now we've got something like 200 million domain names. So just a few more, that's a rapid growth. It's going to be very interesting to see where we are in 2020 and 2025. Eligibility requirements vary widely in ccTLDs today, and they will no doubt do so in gTLDs as they come through. This is just a slide where we split up the registration requirements across Europe, where we've got some unrestricted countries where you need nothing. You can go ahead and file like .co.uk. You don't need a trademark or anything. Partially restricted and restricted, so it varies across Europe. We've actually got 55 ccTLD extensions. The top there, Austria, Czech Republic, etc., where there's no actual restrictions. ccTLD registrations to date are nearly a quarter of the worldwide number of registrations, now 45 million. So again, a lot going on in Europe. And .eu, launched in 2005, a new TLD, not a gTLD, now has 3.4 million registered users today. So in my book, that's pretty successful. The most popular on the bottom there, .com, remains the most popular. Not many people do realize, certainly outside the ICANN and domain name world, that .de is the second most popular TLD out there today. More popular than .net, more popular than .org, and more popular than .cn, although .cn did challenge for a wee while. So talking about the most popular, and this slide's in here because my PA actually did one slide for me and said, you'd best put this in because it took me a long time. So it's here. Germany is the top country. The UK with 9 million follows it. Then the Netherlands, 4.2 million. Italy, 2 million. It's kind of like a Eurovision Song Contest of domain name registrations. It's restricted to the top 10, you'll be pleased to know, or else we could go through for quite a while. But it does give you an idea, again, of the variation and the popularity of ccTLDs. Dispute resolution. Well, many US clients will come to me and say, please file a UDRP in .uk, please file a UDRP in .lv, Latvia, etc. That's one of the big problems we've got to date. We've got 13 ccTLDs who've adopted the UDRP or a variation of it, and I stress variation because .co.uk is quite far from a traditional UDRP, and the .fr has 2 processes again, but it's not a UDRP per se. So the devil's in the detail quite often with these. i.e. I've highlighted there for Ireland, I'll mention that later. We've then got 9 ccTLDs that have no ADR whatsoever. Germany, Greece, Estonia, etc. 3 ccTLDs where you've got arbitration, Poland, Czech Republic and Portugal, and 2 which have specific ADR rules. And really, the slide here is just to say it's already pretty darn complicated, and one of the good things, I think, about the new gTLD process is the UDRP is going to apply across all of them. That is a big thing. Could you imagine 2,000 variations of the UDRP coming along? If that was the case, it would be a nightmare. It would be great business for lawyers like myself, but really not in the interests of most of the world out there. So the problems which brands face today, which is obviously what's going to get a little bit more touchy and difficult in the future, is well expressed by Francis Gurry from WIPO. And I do like this quote because he said, the sale and broad expansion of new TLDs in the open market, if not properly managed, and I think that's the key, will provide abundant opportunities for cyber squatters to seize old ground in new domains. So coming back to .ie, Facebook, and Facebook's mentioned later on in the sessions. There's my oldish profile, which you can't read it, but on the top there, 2 seconds ago, it says, preparing a talk with the assistance of his daughter Ellen and her copious amounts of dribble. So you can post anything up there, and that's great. And everyone wants to know what everyone's doing on Facebook, as you know. Typical classic problem, which Francis Gurry was talking about there. Facebook.ie, registered by a company called TalkBeans. Their logo is your face, your space. So maybe a little bit of a play on MySpace and Facebook there. But no right whatsoever to go ahead and register Facebook.ie in Ireland and point it to a social networking site. So it's clear cyber squatting. There's no issue. We filed a complaint there, got the domain name back. That's fine. But that's the sort of stuff that there is a large concern on brand owners that's just going to happen again and again and again, multiplied across the TLDs. So we filed what was a UDRP there. And if you look at the number of WIPO cases over the years since the first case back in 1999, the decision came through in 2000, you see it was quite high, dropped down in 2003, and then bar the small economic crisis we had in 2008, 2009, where there was a dip, it's on its way up. And we're looking at 1958 cases so far this year, and last year was the highest ever. So again, there's certainly going to be a lot more cases on UDRPs, but will be interesting to see how the URS, which we'll talk about later in the panel, may affect that, and whether it's going to be a more popular dispute resolution mechanism. This slide really just to underline the global nature of the problem, the geographical distribution of the parties. You've got the complainants on the left and the respondents on the right. Some would argue the good guys and the bad guys. You've got the USA are the highest number of complainants, so clearly they're the good guys, but they're also the bad guys because that's where most of the bad guys are as well. France comes out quite well as the second country with the highest proportion of good guys in it, which obviously is why I'm based in France. And interestingly, when you look where the respondents are coming up, we see both the Netherlands and India, we're seeing more and more respondents, and that's where we're finding we're actually assisting clients more and more in those countries. So again, that's to highlight that it's a global problem, and not every country makes use of the UDRP, and we've got this variation in domain name dispute mechanisms across the EU as an example. We've also got what we're seeing now is a tendency towards fast-track procedures. WIPO's got a fast-track procedure in its e-UDRP, fully electronic version. The URS, which we'll mention, one of the rights protection mechanisms for new gTLDs. The Czech Arbitration Court, again, has a fast-track, and Nominet for .uk and AFNIC has the PREDEC, although it's temporarily suspended due to some interesting legal somersaults, shall we say, in France. But this is a clear tendency, and people want these cases resolved as quickly as possible. But you've got to have due process. You can't just take domain names away. So it's complex today, and the point is it's going to get more complex tomorrow. We've already got this cost and the complexity of defensive registrations. You've got an increased number of TLDs, which are certainly going to come around, so there's going to be more opportunities for cyber squatters. Many brands do think, here we go again. They really can't get their head around the fact that there will be something like 1,000 of these coming through and how to deal with it. And so there's a clear need for trademark protection mechanisms. Another factor to consider is the value of generic domain names today. Now, that's not the gTLDs generic, the generic in its true sense. So if you're interested in gambling or money or clothes or toys, and I presume everybody in the room is interested in at least one of those, you see that we've got generic domain names coming through and selling for very high prices. Flowers.com sold for $1.5 million back in 2006. Vodka.com for $3 million. Diamond.com for $7.5 million. Fund.com for $10 million. We're talking a $10 domain name essentially here at the root. Clothes.com, $4.9 million. Toys.com, $5.1 million. I'll come back to both of those. Slots, and of course sex coming in at the highest level. But it shows you really that we've got something happening with generic domain names, and that is driving a lot of the process which we're seeing in new gTLDs. So it's important to remember that that is the case. And we've got brands who are not only looking after their brand as a .brand, but also thinking about should we be going for those goods and services that are protected by our trademarks. So that's where we're getting some interesting discussions. This is clothes.com, pointing now to Zappos.com. Zappos.com purchased by Amazon.com. So you can see again where that's going. Interesting when you look at the balance sheets when companies are purchasing and selling domain names, you've actually got generics in there, and these are being highly valued for the purchase price. So it's certainly a business in its own self. And all these are creating issues. We've got automatic registration software, as most people will know. We've got the growth of registrations. Each year, they are continually growing. There's never been a dip that I've seen. The cost of bringing action before the courts remains high, and it always will. We've got this variation of dispute resolution policies today. We've got IDNs, which I'm certainly not going to talk about as a subject in its own right. And then we've got all this abuse, which we're seeing today in the DNS, the cyber squatting, the gripe sites, pay-per-click, maybe a little bit less now, false affiliation, domain kiting, etc. A lot of stuff out there trying to scam the users. And we've got many new gTLDs around the corner. So we've got the issue of consumer confusion and trying to reduce that. And we've got the multiplication of threats to IP rights holders. So moving on to the second part now, new gTLDs themselves and how this landscape's going to change. I've tried to paint you that picture of where it is today, and it's fairly multicolored as it is, and it's going to get a bit more color splashed on. Going to look at preparing for the launch itself, cover a few pros and cons of applying, because again, brand owners looking to protect their brand need to be considering .brand, and then finally on the timing. So we are looking at this unprecedented shake-up. I don't think anybody denies that. We don't know how much it's going to be shaken up, but it's certainly going to be considerable. And whilst the aim is to enhance diversity, choice, competition, and innovation, it will inevitably cause considerable burden on rights owners. We do hear figures quoted about for, it will cost our brand $12 million to protect ourselves, etc. It may cost 12 million, it may cost 1 million, it may cost 100,000. At the end of the day, it's money which a lot of brands don't want to pay out to register defensively, and ones which the idea behind the rights protection mechanisms are there either to assist brand owners to do it, to get out the bad guys, or to have mechanisms in place so that the bad guys don't register and you get clean TLDs, which I think everybody would like because then we have less litigation. But why? Coming back to enhance competition, promote choice and innovation. Well, if you're looking for a hotel in Munich, either to come to Oktoberfest or to come to this conference, which I expected many more people to be dressed up in those lederhosens, but not today it seems. You'll be looking for a hotel, and you actually find quite a bit of difficulty getting a hotel in Munich, as I did, but that's because I was very naughty and only applied very late to Marcus for my hotel. But luckily I went to Marcus. I should have gone to .Marcus perhaps. But otherwise I could have gone to hotels.com. I could have gone to hotels.de. In the future, I might go to munich.hotels. And I might even go to hotels.munich. So yes, we've got the competition, we've got the innovation, but also I may just use Yahoo, Google or Bing. So that's one of the problems we've got to look at. What are new gTLDs? This has already been covered. It's a very high level. It's really, there's nothing new apart from it's unlimited. That's the whole scary thing about it. It's not 7 coming through. It's not a finite number that we've seen. We've had all of these drafts of the guidebooks. We've had the final one there published on the 19th of September, and I put final there just in case Kurt decides to add in something else and it becomes almost final. And it's both a threat and an opportunity to business and brand owners. We've seen perhaps some 170 applicants making noises that they will be applying. There still seems to be quite a few people thinking that they've already applied. The number of clients I talked to and said, but it's already gone. They've already got that. And I said, well, they haven't got anything yet, but they've been saying it for so long. I said, yes, and they're probably tired of saying it as well. But many are out there keeping quiet. Of the ones that are making noises, here's some of the city domain name applicants, which we've seen. Here's some of the regional domain name applicants. And here's some, what I call the industry's goods, services, lifestyle, keywords, everything else. Again, quite a variety there of these words, the .hotel, .real, .surf, .ski, .eco, etc. So a lot out there, potentially. Big question, are brand owners going to be left out in the cold? Well, we don't know. That's not me on the right, by the way, in case you were wondering. This is Brighton Beach, so it was unexpected seeing that sort of snow there. But there we have it. Are brand owners going to be left out in the cold? And brand owners are certainly now focusing on new gTLDs, having probably argued and tried to delay them as much as possible for a couple of years at least. Well, there's only 2 at the moment still publicly said that they will apply, .canon and .hitachi. There are a large number out there, as many people in this room would know, and I think if we all wrote down on a piece of paper the ones we were aware of, Kurt would be very happy to collect all of those pieces of paper at the end and actually tally them up and put that in the database. It would be a very interesting number to see what generally would be coming through from brands and from other generics. We've also got a not-for-profit, UNICEF. Their idea is saying, taking the long-term view as time goes on, such names such as donations.unicef, cards.unicef will become more intuitive in a more crowded internet and thus more valuable. So that's where we can see that UNICEF stating what they're wanting to do and why. The concerns to IP owners, well, potential for significant increase in cyber squatting, that's what I've said earlier, at the second level, so this is under the .London or whatever it may be. So the increase in defensive registration and dispute costs is all a concern. So we may see things like Olympics.London coming through, because Olympic is on the reserved name list, but Olympics isn't, as far as I'm aware. So that'll be interesting if someone goes and says, well, you've reserved Olympic, but I'll have Olympics, thank you. Microsoft.Web, they might not be too happy if there's .Web coming through. Unlikely to be a .Paris. Will Louis Vuitton get their .Paris, or will somebody else get there first? Those are the typical examples. Risk of cyber squatting at the top level, I don't really believe that exists. There's not many cyber squatters who are going to pay $185,000 for the chance of registering a brand only to lose it later on. It works on $10 domain names. It doesn't really work at $185,000. So that's one of the good sides of ICANN having a high price there. You've got a risk, though, of permanent string preclusion at the top level. Quite possible, taking this example, I didn't want to name any clients' names, and I got a little bit tired of putting my cat in there, although he does make an appearance at the end here. So I put my daughter in there, .Ellen, and if she was wanting to apply and somebody had already registered or secured .Allen, there may be an issue, but I'll leave that for discussion, perhaps. So we've got the existing RPMs, and we've got this wonderful thing called the Uniform Domain Name Dispute Resolution Policy, which I mentioned earlier, which is still doing very, very well, a number of providers around the world. It's a very useful mechanism to get domain names back, but there's no damages involved. So it has its limitations. But that's there. It's the castle protecting the brand owners. But there was a definite discussion and a need for new ones. And Kurt mentioned this earlier, but there was the IRT, the Implementation Recommendation Team, which was created back in 2009. And its task was to develop and propose solutions to the overarching issue of trademark protection in connection with the introduction of new gTLDs. And as Kurt said, I had the honour to be on that, and I suddenly realised that there were 17 other people out there who knew a hell of a lot about domain names, and it was one of the most interesting periods I've ever gone through. It was also interesting because I received the fax asking me to be on it, and it came through, and I had 24 hours to reply yes or no, which was kind of a ICANN internet speed. And I thought, well, what do I do with this? And I thought, obviously, the first thing I do is ask my wife, should I do this because we're expecting a baby called Ellen? And then she said, well, you can hardly say no to something like that, can you? And I said, well, but I probably should because you're having a baby. And she said, well, how long will it take? And so I read briefly through, and I think it said something like 15 days. So I thought, oh, yeah, I can manage 15 days. So I just sent it off quickly because I needed to send it off quickly. And then what I hadn't read was it was 15 days over an 8-week period, which suddenly, and then I thought, that's actually 3 weeks then of 8 weeks. That's a little bit harder. In the end, the time on the file, as all lawyers do, I had approximately 38 days' time down on the file spent on that. So it was phenomenal. And that did cover what we did afterwards as well. But it was an amazing experience, and one of those things where you bottle up a few people in a room and hope they come out with something which is vaguely credible with all the limitations which it had. But the timeline here, again, for those coming late who hadn't been at ICANN meetings, there's been a bumpy ride for RPMs. If we go back to the Mexico City ICANN meeting, where the IP community requested enhanced trademark solutions back in February 2009, to the recommendation team, through to global consultations, as Kurt mentioned, and then through to the GNSO and the special trademark issues, STI. It's gone right the way through to September 2010 with INTA weighing in heavily, complaining. And then we've seen this year, again, won't go through the whole process, but continued discussion, pressure being brought, the GAC, Governmental Advisory Committee, bringing a lot of pressure, and IP lobby pushing in, shall we say. So a lot's changed, and we've ended up with the final applicant guidebook on the 19th of September. The problems and the solutions proposed. Well, one of the big issues is the cost and the administrative burden to rights owners of each and every sunrise which comes along. If you looked at .asia in 2005, sorry, .eu in 2005 and .asia in 2007, very different sunrise periods, different trademarks involved. Great business explaining to people, because people would get it wrong as to which trademark to file and which trademark to use, but very different. Again, it works if you get one every couple of years like that, but not if you get this influx of 500 plus coming through. So the idea here is to try and get consistency and putting in, it's basically a database, you put in your trademarks into this trademark clearinghouse to be used by the registrar's registries. The other solution which we proposed back then was to deal with the cyber squatting continuing, consumers being misled, the fact that the UDRP, some say is quite slow, courts taking time and the money, so the URS proposed. Again, the idea of being rapid was the key thing, and that went through an evolution, which I'll come to a little bit in a minute, where it was getting a little bit slower, and then it's come back pretty much where some would like it to be, and some would like it to be a lot quicker still, but I think it's probably fair where it is today. What to do with a registry operator who acts inconsistently with representations or has bad faith intent to profit from systemic cyber squatting? The PDDRP was the solution here, as a way of going after the registry operator rather than going after the registrants themselves. So this is kind of a little bit like you don't go after the counterfeiter, you go after eBay. If they're doing something really wrong, you can go after them, and that's the way it should be, in all honesty, because you shouldn't be turning a complete blind eye to systemic cyber squatting in a TLD. So hopefully that will be a weapon which won't be used, full stop, because it will mean that registry operators will behave, so to speak. And then THICU is, there was no single source of available data, but that one's luckily has evolved where we want it to evolve. So a couple of words on the URS. I've put there rapid because that's what it's aimed for. I gave a talk back at the ICANN meeting in Brussels where I said it was, the R now stands for redundant because it was so long, and I thought it had become pretty pointless, and I couldn't see why any brand owner would want to use it, and so now it's replenished. But if you look at it, you'd file your complaint, you've got a form complaint, put in the trademark, the grounds, who is, and 500 words to explain why you want the domain name. You've then got this administrative review, notification to the registry operator, and the domain name being locked within 5 days. So that's pretty good, although it doesn't take the content down. The registrant gets notified and then has 14 days to reply. That used to be quite a bit longer. Now it's down to 14 days, with 7-day extension being possible. And then we've got a decision date goal, i.e. 5 days is what's allowed, but the goal is 3 days. So we're looking at 32 days now, which is significantly more than it was. At one point we were looking at 47 days. There's still the possibility for appeal here, so again, anybody who is really having their domain name taken away or suspended from underneath them can generally appeal. And looking at a review of the URS after a year to really see if it's working and how well it's working. So I think all good points. Again, this is one of the things with the EUDRP with WIPO, really just to show timeline and the difference. We filed this case, which was actually the first EUDRP back for Nokia back in 2009, and that took 35 days from filing to finish. So again, it's quite a quick UDRP, but we're seeing, as I was saying before, that the mechanisms are getting quicker generally. So at the one side, we've got the UDRP quickening up whilst this URS is being created. So we're looking at something which is a little bit closer, but the result is suspension in the URS as opposed to a transfer. So the main solutions there proposed, and I've put out on the right there the GPML list, kicked out and teed up on top of the Eiffel Tower in Paris, because it was actually the most requested solution from brand owners, and it's the most difficult one to deal with because everybody loves the GPML as long as they're on it. So where do you draw the line? And if you're not on it, you don't like it. So hard to get agreement anywhere, let alone amongst brand owners on that one. So looking now at the opportunity for brands, well, there is obviously this possibility of registering dot brand, which in a way mirrors the challenge that they're facing. Very high level here, because this is what we'll be talking about over the rest of these 2 days. You've got this 185,000 application fee. You've got these 50 questions, detailed answers. You could be looking at applications of 100 pages or more. Issues, technical issues, full external evaluation by industry experts. Key point, substantial financial resources needed to operate or pay for outsourced operation. And applicants needing to provide funds in escrow for 3 years in the event of a business failure. So, and you've got the additional fees on top. So it's not for the faint-hearted to go after one of these TLDs. Some of the potential pros for a brand owner, just throwing out ideas here, certainly enables brands to be in charge of their own TLD. You have complete control under it, anything .brand you can have. You're protecting your IPR. Currently there's no coexistence out there, but you're also potentially getting a broader protection of the brand if you've got your .brand. So new gTLDs that are confusingly similar, which are registered down the line or want to be registered down the line, may not be permitted. So you could be getting on a good thing. Enhances brand promotion, visibility, you're defending assets and market position. So a lot of these issues, it may be right for some, it may not be right for others. Certainly a first mover advantage. We heard earlier about when the next round will be, and clearly nobody knows when the next round will be, whether it's going to be something a little bit more continuous, but there's going to be an advantage, whatever way you look at it, in applying early on. The question is whether that advantage is what you want. And again, just mention a couple of these, not losing ground to competitors. I mean, that's the biggest thing I see with .brands at the moment, is everyone is thinking, well, we'll do it, but it depends. Are they doing it? And of course, no one's saying whether they're doing it, because it's all very hush-hush. So everyone's really looking to see what everyone else is doing, which makes it very interesting, because I would say well over 50% of the clients I'm talking to still haven't committed because they're still trying to find out whether their competitors are doing it. So it gets quite interesting. So those cocktail parties are becoming more and more interesting when you're talking and people are trying to get information out of you. So ply me with drinks, because I love the drinks, and I still don't say anything, I think, but I can't remember if I do. Anyway, risk of permanent string preclusion, I mentioned earlier there. To ensure prevention of user confusion, we've got this string similarity algorithm in there. Any string yielding a similarity of 30% or more is cited. And putting there my Ellen example, if brand Ellen didn't apply, because my daughter's got this wonderful brand and she's wanting to use it at age 2.5, and a string similar to Ellen was applied for instance, Alan gets his .Alan, then later on when Ellen gets a little bit older and she can actually apply, and she wants to apply for .Ellen, she might not be able to get it in a subsequent round. So she might be quite miffed, especially if Daddy didn't get his ducks in a row early enough. Some of the cons of applying, well, uncertainty in relation to the success. Nobody knows how many are going to come and how successful they'll be. Are we looking at a dead dodo? Perhaps. Who knows? .com value, well, it's here to stay in the medium term. It's still going to remain the premium domain name space. The competitors I mentioned before, the relatively high costs of applying, need considerable management focus over the next 24 months. Any brand who thinks it's something they can just delegate to somebody outside just to do it and not really consider it in-house may have a few problems. And ICANN has developed this for communities and investors. It wasn't developed for brand owners, and I'll mention this at the end, but I'm fairly convinced that over 50% of the applications will inevitably come from brands at the end of the day, but we'll have to see about that. Business plans, again, when registering a TLD as for a .brand, it's always what do you intend to achieve by registering it? What are the business drivers? Obviously, thorough answers are needed, and a lot of brands don't want to put the business plans out, as most people don't want to necessarily put them out. There's always the risks of confidentiality and concerns there. Again, competitors, what are they doing? There seems to be the search for the Holy Grail. We actually had one talk with 6 clients where they were all discussing whether they would tell the other 5 clients whether they were going to do it or not. And I had separate conference calls one day, and at the end they decided that they couldn't have that conference discussion between them because of various management said that not. But that was close. That would have been nice to have 6 brands talking to each other and listen in. So how will the new gTLD be run, whether it's a standard or community gTLD? Who can apply? What are the rights protection mechanisms to employ? Will it only be available to customers of the brand? Will it be used for internal corporate IT? IDNs, will they be offered? Who will the abuse point of contact be? Mark Zuckerberg, probably. And how will the ownership and operation of a new gTLD fit with your current businesses? So looking at the anticipated timeline, which we've seen, on the 30th of May, we had the almost last version published. In Singapore, we had the ICANN meeting there and the board approval on the 20th of June. We then had the final applicant guidebook just a week or so ago, published. And then we've got the application window opening for 3 months on the 12th of January. And there doesn't seem to be any slip so far as I can see on this. And then we'll have end of 2012 and beyond, many, many more. So in conclusion, new gTLDs are coming. There's still quite a few brand owners out there who think that they're not, which surprises me. It's likely to cause a radical shake-up in the DNS for sure. It is a threat to brand owners. Brands need to reassess defensive registration strategy, portfolio management, budgets. All those things do need to be looked at. And it needs to be looked at now, really, because we're talking 2012. Some of these could be appearing. So it's a good dry run to get budgets in order for 2012, because they'll likely be a bit bigger in 2013. It's also an opportunity for some brands. And brands need to fully consider whether to apply or not, and all of the pros and cons. And I put there for some brands, because I generally think a lot of brands don't need to do this at all. And I've said to many that they shouldn't, and I don't see any reason for them doing it. What surprised me is some of those brands have said, but we still want to do it, which shows that really nobody listens to me anyway. But then we've got some clients who I sit and think, you've got to do this, this is the best thing ever. And they say, no, we don't want to do it. So I'm confused. Is this working? So the application window's set. We've got a 90-day window from the 12th of January. Key thing there, don't leave it to the last minute to apply. I think everybody in this room who's assisting brands or generics or businesses, etc., would be very much like to know a little bit earlier than the 29th of March whether or not the client's going to go ahead and do this, because everyone's got bandwidth problems, so that's a key thing to bear in mind. And my battery's running out. Oh, and I mentioned there before, my estimation is that over 50% of the applicants will come from brands. And just to ponder, and almost end with, if Toys R Us were willing to pay $5.1 million for Toys.com, which is one of those generics I mentioned earlier, yes, $185,000 is a lot of money. Yes, with consultancy fees, registry operator fees, etc., $500,000 US, perhaps to $1 million for something like .toys is a lot of money, but is it that much when you pay $5.1 million for Toys.com? I don't know, we don't advise them, so I can mention that. I've no idea of the answer, but it intrigues me to see, and I'm looking forward to having a look for this one. And so, new gTLDs, well, who needs to bother at the end of the day? Is this just a game of cat and mouse? Well, if it is, my cat's preparing. He's been preparing for a while, so watch out. And thank you very much for your attention.